Good, bad, like, dislike, whatever it may be. Niceties of the law can be understood by a good council. Niceties of the laws can be formed by the good judges.
Mr. Bandyopadhyay, why don't you
No, no.
stop your pleading?
I am saying,
Person has delivered a judgment. Partho Chatterjee's matter was being argued when it was being said by the learned council, see how the learned judge is vindictive. I stopped the hearing. I said I shall not hear it.
no, I am saying of the ninth, subject to condition that those who will be appointed without professional qualification shall acquire the professional qualification within a period of 2 years from the year of appointment. Well, this is a very important part of this matter. And that this argument, Milord, if I am right, this argument will establishes the learned judgment, reasoning of the judgment of the learned single judge was contrary to the Milord, the advertisement notice itself. What it speaks about, the relaxation, if you don't have the 2 years, this diploma in elementary education, you can make an application. If you make an application and you are appointed, well, this is very important word, if you are appointed. If you are appointed, you are giving a chance to complete the course within 2 years.
Yes.
Distinction in this case is, my lord,
Yes.
we were not having the 2 years diploma course at the relevant point of time when the application was made. Neither we were not the petitioners, right? But we were appointed.
On the basis of such relaxation.
On the basis of
Such
no relaxation, we were appointed with a condition 2 years have been that we have fulfilled. I will show to it. But they were not appointed, therefore they were not entitled to be enjoyed this clause.
Yes.
This is a basic distinction of the matter itself. The learned single judge has gone on a reading that all are not 2 years course are having, therefore they are disqualified. But the note one speaks that those who are appointed, they will get the chance to complete it within 2 years.
Yes.
But not in their cases it is applicable because they were not appointed. Then
are they disputing that you were not entitled to this relaxation? Is the court saying that you were not?
Court is saying.
Court has what finding has been written?
Court has given. I will show to you. Yes. Take it from me now. Court has said they are untrained. We are also untrained.
Yes.
We are not qualified.
Both the groups are untrained. When they have been given, you have not been given. You have been ousted on the basis of a faulty aptitude test. This was the reason.
This is the case. Therefore, I have given because I was appointed.
On the ground of relaxation, it was not turned down.
The court has not taken note of the relaxation even. Court has not taken the note of the condition of the advertisement even. All right. My point is the learned single judge has not taken note of the advertisement.
Yes.
Learned judge set aside. We have not made parties. Today also I am saying, my lord, the learned single judge judgment should be set aside because we have not heard.
Yes.
Well, on 2 counts, I will say that this order is required to be struck down. This order is required to be struck down for not getting a chance of hearing for 2 reasons. One of the reasons we are not heard. Second most important reason is this. The learned single judge has relied upon the evidence of different witnesses. Did I get the opportunity to cross-examine them?
Yes.
I have not got the chance to cross-examine them. Firstly, if the matter was not to be heard without hearing the affected parties, is a right proposition of law. Is a right proposition of law. Then secondly, whether an evidence can be relied upon without giving me a chance to cross-examine them.
Yes, yes.
Therefore, both the two counts, this judgment is alone to be is required to be set aside.
Yes.
Whether board has examined or not examined, what are the board's intention, board choice, I am not concerned about it. I have not got any sympathy from the board, rather petitioners have got sympathy before the learned single judge from the board itself.
Yes.
Not a single point has been raised before the single judge. At the very first day, when the petition was moved, board was supposed to take the point of the maintainability. Or board should have said that the appropriate, the persons who are affected, they should be made parties. At whose interest the board have not done it. For today, if there is a violation of natural justice in the trial court, this judgment is needed to be set aside alone on that ground.
Yes.
Which is, if I had an unfair trial, if I have not heard it there, my lord, with great respect to your lordships, my lord, in an appeal court, your lordships cannot correct that.
Mm.
If it is sent back, a judgment comes, again I will get a forum of appeal. I cannot be deprived of a forum of appeal.
Yes.
And two important counts I have given. Not heard, not cross-examined. Not heard, not cross-examined. We are making so much research. The learned single judge should have also made so much research. iPad is given, SCC is given, will not check it up whether the High Court has passed a judgment or not. Two different coordinate benches judgment. My lord, kindly do not mind, my lord. With respect, I will tell your lordships, from 2016, so many judges were there. They were sitting, my lord. Justice Mousumi Bhattacharya was sitting. Justice Banerjee was sitting. Justice Hiranmoy Bhattacharya is sitting. Other judges were sitting. Nowhere they have gone. Went to this court. Is it not forum shopping? Was it not a forum shopping?
Yes.
When you have felt convenience, then you have gone to that court particularly. Unfortunately, I have to say, the recently very Chief Justice of India has delivered a speech and said, it is unfortunate in our country, the sitting judge resigning and joining political
My
party.
lord, Mr. Banerjee, why we are going into these issues?
My lord.
Let us stick to the facts.
Yes. That is a part of that.
Please, Mr. Banerjee. Yes.
That is the forum shopping. What other materials have been placed here? Whose responsibility, my lord? Responsibility of the petitioners? Here in this case, court has taken the responsibility on its shoulder. One of the presiding judge of this court in the niceties of the laws may not be understood by a very mediocre judge, but the great judges have made these niceties of the law. And that is the law of the country. That is a binding under Article 141 of the Constitution of India. If you don't understand the niceties of the law, you don't deserve to remain as a judge. You have to follow the niceties of the law. Law prevails over everything. Good, bad, like, dislike, whatever it may be. Niceties of the law can be understood by a good counsel. Niceties of the laws can be found by the good judges.
Mr. Bandyopadhyay, why don't you
No, no.
stop your pleading?
I am saying,
Person has delivered a judgment. Partho Chatterjee's matter was being argued when it was being said by the learned counsel, see how the learned judge is vindictive. I stopped the hearing. I said, I shall not hear you.
no, I am saying of the niceties of the law have to be
Mr.
followed.
Bandyopadhyay, you explained to us on
No,
the
I am
ground of
saying,
all these judgments according, we have not heard.
I am saying kindly, no, your lordship is misreading.
Mr. Bandyopadhyay, why should you?
I am saying niceties of the law have
that
to be
we
understood.
yes, yeah, all right.
That's right. That's why I'm saying.
Once the niceties are not understood, you cannot blame the judge, na? You cannot say that the judge doesn't understand.
If the judge, yes,
No, that
Niceties of law has to be understood, my lord. We are in the legal, no, my lord. After all, we are in the peripheries of this. You can't ignore a law because this is the niceties of law.
yes,
Judge is making questions one after another.
we have seen that.
Therefore, whether the judge had the role of the prosecutor or the judge,
Yes, that we have seen. That has been argued also before us.
anyway, just I am reminding to us.
Yes, yes.
Therefore, a judge cannot be prosecutor of his own case. He should judge.
Actually, aptitude test হয়েছে তারপরেও
Anyway, I'm not going. This is the way. Evidence are given to you. No, all questions have been raised by the judge. Was it a proper procedure followed under section 165 of the Evidence Act?
Proper procedure meaning what was the procedure?
165 procedure, see the procedure.
That is up to the discretion of the judge concerned.
Discretion. Evidence may be called. Evidence may is a discretion.
Hmm.
But judge will not be a prosecutor.
No, that is separate. Judge will not be the
But
prosecutor.
discretion, if you exercise the discretion, you have to give reasons.
Yes, yes.
But there
It
is
was put by the judge, na? You are there.
dead party है
Oh, if anybody of you
Tiwari.
might be,
Tiwari was
Huh?
Mr. Tiwari was there.
where is Mr. Tiwari?
Questions were
Anyway,
put to the
it was put by the,
no,
by-
the losses have seen the questions have been
Yes,
put
yes.
by the all the questions. And thereafter, board has been asked to cross-examine, board did not cross-examine.
who did not cross-examine?
Board. As per
Yes,
record,
Board, Board said we had didn't we were not given the opportunity also.
What?
That was we were not given the opportunity.
that's all right. Very good board in this case. Then today what would be done? If this evidence, your lordship, if he upholds the judgment, reject our case, then on the basis of the reasoning, and one of the reason of the evidence,